Assalamualaikum and good day everyone. I am ATHIRAH and my metric number is 055340. Today's presentation is about our group's drafted act entitled Social Media Defamation Act 2022. It comprises of 5 parts which are preliminary, general provision, liability, contents and posts, and miscellaneous, which are accompanied by 20 provisions. This act purports to regulate matters regarding to defamation on social media. Our group consists of 5 members. We divided our discussion into 2 main jurisprudence, which are Islamic and Western jurisprudence. For Western jurisprudence, we focus on natural, positive, sociological, Dworkin, and feminist jurisprudence. I will be focusing on the application of Islamic jurisprudence throughout this act. The foundation of Islamic jurisprudence is in accordance with Sharia law. The objectives of Sharia law are demonstrated in Maqasid Sharia, which consists of several objectives such as protection of dignity. As for that, Maqasid Sharia, specifically protection of dignity, is connected with the purpose of our drafted act, which concerns on the defamation. First of all, how does the protection of dignity relates to defamation? Back to the definition or requirements of defamation provided in this act, referring to the listed provisions, it can be inferred that the purpose of the defamation is to tarnish a person's reputation, which is in contravention to the objective in Maqasid Sharia, which is to protect the dignity. Hence, the act is drafted in line with the obligation to protect dignity, since this act makes defamation as an offence punishable by law. In Islamic jurisprudence, numerous reliable authorities are mentioning and discussing on defamation, the main subject matter of this act. The ruling concerning this matter has been explicitly stated in Surah Al-Hujurat, verse 11, do not defame others. Next, according to Surah Al-Hajj, verse 30, always speak the truth, shun words that are deceitful and ostentatious. However, in Surah An-Nur, verses 15 and 16, if you do not have complete knowledge about something, better keep your mouth shut. You might think that speaking about something without full knowledge is a trivial matter, but it might have grave consequences. For example, this act prohibits any defamation made toward women under Section 10. Any end user has no right to post or spread any content that the truth behind is uncertain. We are in no position to judge them based on groundless speculation. Referring to Section 14 of this Act and its illustration, everyone also has the right whether to disclose their past or not. Do not treat them like they don't make mistakes just because they are someone who brings the image of their religion. We are not allowed to assume and guess about others' private life because it might be prejudiced against their reputation. Furthermore, the protection against defamation stipulated in Section 5 makes it available for everyone who is identified to suffer from defamatory remarks made through social media, according to Surah Al-Ahzab, verse 58. As for those who abuse believing men and women unjustifiably, they will definitely bear the guilt of slander and blatant sin. Those who are found liable for committing defamation under this Act will be punished accordingly. Since Islamic jurisprudence concerns the relationship among fellow human beings, hablum minan nas, therefore do not persecute each other. Moreover, several provisions under Section 13 of this Act are drafted based on the insertion of the hablum minan nas concept. For instance, under Section 13(2)(a) of the Act, a person shall be liable if the act is done with the intention to create sentiment issues concerning races in Malaysia. Any defamatory remarks based on this section will raise the possibility of chaos and will disturb relationship between Malaysians. Besides that, as we know, the religion of Islam is highly associated with morality. In the Act, there are a number of provisions that provide sanctions which are particularly concerning on regulating the behavior of the people to not commit any immoral acts on social media, especially if it degrades the reputation and dignity of a person. To sum up, defamation is a grave wrongdoing which perceives great weight in Islamic jurisprudence.
Assalamualaikum and good day to Sir Shafiq. My name is NURSARAH Sabrina and my metric number is 055310. I'll be explaining provision that represent natural law school based on the Act from our group project, Social Media Defamation Act 2022. First and foremost, let me provide a little bit of information on natural law. Natural law can be understood as a moral theory of jurisprudence and often states that laws should be on the basis of ethics and morals. This law also states that law should focus on what is correct. In addition, natural law was found by humans on their disposition of reasoning and choosing between good and bad. Hence, it is said that this law plays a significant role in establishing moral and ethical standards. Moreover, this school of jurisprudence represents the belief that there are laws common to all societies. This is irrespective of whether they are written down or can be officially enacted. Lastly, this school of thought tells us that law is both rational and reasonable. Therefore, actions that are morally wrong will be against the law, but also actions that are morally right can't truly and justly be against the law. Natural law exists regardless of what laws are enacted. Moving on to the provision, I choose Section 9, Clause 3 of the Act. Section 9 generally is in regards to the liability of the service provider. Section 9, Clause 3 of the Act reads that, nonetheless, the owner of the account who made the defamatory remarks shall be given an opportunity to justify him or herself by submitting an explanation of the defamatory acts to the service provider. The reason as to why this provision is included in the Act is to avoid any injustice from occurring by hearing the stories on both sides of the parties. In this way, it will simultaneously give a chance to the accused to defend him or herself by providing any evidence that is useful to the case. This is aligned with the rule of aude alterum partem, which derives from a Latin phrase that means hear the other side, or the other side is also heard as well. This is a strong principle that no person shall be judged without a fair hearing, and also bring a meaning to giving each party an opportunity to respond to the evidence against them. Aude alterum partem is a very important term that helps to achieve natural justice for every accused and to prove their argument with evidence. The execution of natural justice depends on the option exercised to hear both sides before deciding a case.
Assalamualaikum warahmatullahi wabarakatuh. My name is Dania with SALMIZI with matrix number 054961. Today, I will explain on the legal positivism viewpoint on our Act of Social Media Defamation Act 22. So, basically, legal positivism is a legal philosophy or theory of legal jurisprudence that does not consider the underlying merits of an applicable law or whether the law is morally right or wrong when evaluating whether a law governs behavior. The legal positivist accepts approved rules and law as law, whether or not he or she agrees with them from a moral perspective. So, Bentham is one of the legal positivists. Regarding Bentham's theory of law in legal positivism, he promoted for codification of law and argued that common law or arbiter law suffers from indeterminacy that is basically vague, uncertain, and difficult to determine. Accordingly, he was known as advocating the doctrine of utilitarianism, which defines virtue in terms of utility. As an example, we may approve or disapprove an action according to its tendency to increase or diminish happiness. Based on this principle, to achieve the greatest happiness of the greatest number was accepted as the true goal of society. Therefore, if punishment of an offender is to be administered, it must be demonstrated that the punishment will help to prevent greater general pain. The punishment should not be as rigorous, but must act as deterrent. To correlate with the legal positivist viewpoint with our Social Media Defamatory Act 2022, it can be seen in the sanctions section, which is the section which contains the punishment or penalty to the offenders. In our Social Media Defamatory Act 2022, it laid down the cyber protection towards the defamed person. It can be seen in Section 5 of the Social Media Defamatory Act 2022. Another example can be seen in Section 7 Clause 4 of the said Act, where it states that any person who is found guilty under the subsection 1 and 2 shall be fined in accordance with the penalty prescribed under Part 3 and Part 4 of this Act. Meanwhile, Section 9 Clause 4 stated that the failure to comply subject to subsection 1, 2 and 3, the service provider shall be punished with a fine not exceeding 1 million ringgit. Meanwhile, Section 10 Clause 4 stated that in action for a defamatory remark in respect of words calculated to disparage the end user in any profession or calling or trade or business held or carried on by her at the time of publication, the person will be liable to imprisonment maximum of 1 year or fine not exceeding 50,000 ringgit or both. In the light of the stated section that I mentioned just now, let's see more clear example where I will be giving you in education context. Defamatory act that happens in the context of education can be referred to Section 12, Subsection 2 of the State Act, where it provides that if any content or post made through social media, either by the educators or the students, contains any disparaging remarks towards the educational institutions which may deteriorate their image to the public or other possible student, the person shall be liable. The sanction that will be implied is states in Section 12, Section 4 and 5, where it provides punishments such as suspension for student and teachers, expel for the student, fine and imprisonment. As we all know, punishment or sanction has their own purposes. The purposes of sanction or punishment will lead to a better world as it prevents the future crime by frightening the offenders or the public as they are afraid to the said crime or to repeat the said crime.
Hi and Assalamualaikum to Shafiq. My name is SITI ARISYA binti MUIZUDDIN with metric number 055286. Today I will present the Social Media Defamation Act 2022 from the perspective of one of the core Western jurisprudence, which is sociological jurisprudence. This jurisprudence focuses on the relationship between law and the society. Therefore, our statute aims to study the importance of law towards the social media usage to avoid any act of defamation that can disrupt the social interest. Roscopan, one of the sociological scholars of this jurisprudence, mentioned that sociological jurisprudence is to enable society's members to make efforts to safeguard their interests and ensure that their views are heard. Roscopan presents his social engineering hypothesis, which is responsible for constructing societal structures that involve two essential goals, which are maximizing enjoyment and minimizing the friction. In relation to our statute, Part 2 and 3, which comprises Section 489, can be a clear illustration that while an individual is permitted to use social media in Malaysia, it is still up to certain boundaries to ensure that the freedom that has been granted will not be misused to do harm or injury to the society or other peoples. Further explained per Section 9 of this Act, a social media service provider such as Instagram, Facebook or YouTube should first inspect the posts that want to be posted publicly by their users. Then they should take down, investigate and suspend the account that tries to post any defamatory content towards other people. This action is vital because most of the defamatory remarks on social media may cause disharmony and disunity towards the society or the community. Following Section 13 of this Act, although all users have the right to use social media to write a statement or post videos or photos about any issue relating to their patriotic or national identity, they still can be found liable if their contents or posts harm the image or cause disrespect by society towards a person, culture or things that carry the significance of the country. Furthermore, under Section 14, in the context of religion, a person may be halted from posting any content on social media involving the history or past of the person who brings the image of religion or their belief. From a sociological point of view, this is incorrect and wrong because while the user has an individual interest in posting the contents, it still causes chaos in the societal interest. After all, the religious influence reputation can be tarnished and the public will be skeptical about any religious matters or issues brought or spoken up by the said influencer. Next, Rudolf von Jhering emphasized that the legislation exists to serve the individual's interests while keeping the greater benefits of society in mind. In another word, individuals will be happy if the society is happy. Pursuant to Section 10 of the Act, it aims to provide safe and secure social media platforms for women to post or upload content. This section seeks to minimize the possibility of of slander or libel toward women. They should not feel harmed to post any content because they fear that any person might defame them for the purpose relating to adultery or unchastity. This interpretation could also apply to the minor under Section 11, where the parents should not feel harmed when posting their child's photos or videos on social media. Therefore, any person is prohibited to share any contents relating to the minor with or without the consent of their parents or guardian if it is related to the defamatory posting either towards the minor itself or other people or entity. Thus, as a result, the Social Media Defamation Act 2022 designed to balance individual and societal interests to ensure that society is free of any issues or harm.
BINTI ARIFFIN, I will explain about the feminism and look into jurisprudence from the provision. Let's look at Section 3 and Section 7 of the Act. Section 3 provides the definition of defamation and announcer. Meanwhile, Section 7 provides the liability of the announcer, either he or she made or received any defamatory remarks. From this section, they have blended with two jurisprudence which are Durkheim and feminism jurisprudence. From the feminism jurisprudence, it more preferable of liberal feminism. From the liberal feminism, it derives from the principle nobody benefits from the existing inequalities. Both men and women are harmed. The key of the liberal feminism is belief that equality is possible and eventually occur. Next, Durkheim theory, we derive from the principle of luck egalitarianism, which to make people equal so far as it is possible in the resources which they face uncertainty. The key for this jurisprudence is equality. Both men and women may be the victim of defamation either in slander or libel. No one should suffer any defamation through any publication or statement that will suffer people's reputation. Moving on to the section 10, which is focusing on defamation towards women. This subsection is derived from the radical feminism jurisprudence that theme oppression. The radical feminism targeted sexual domestic violence assault that oppress on women. Therefore, based on this jurisprudence, no woman wants to be the object for lust by any person, especially strangers. Any type of the signs or material is considered of instrument of sexual subordination rather than creative expression. This section consists in the perspective of Marxist feminism, where the social classes and maintain that these social classes are also becoming the reasons of oppression against women. This is because women got their position and achievement by struggling between social classes to show that they are independent women, a woman who supports herself on her entirely and no one has the right to oppress her about the achievement. No one can take away her self-confidence by any slander and libel. In this section, we have blended with positivism jurisprudence. The feminism jurisprudence is the theme of oppression, while the Austrian theory is command of the sovereign. That being so, subject to subsection above, no woman shall be oppressed by any person. Thus, blended Austrian theory, the sanction of imprisonment and fine would make people fear of this such offence. Last but not least, Part 5 of the provision. Section 21 provides the rights of the court in interference if there is any conflict arising, per stated in the clause. In this section, the concept of Hercules is derived from Durkheim theory in Law's Empire. Hercules is an ideal judge who is wise and full of knowledge of legal sources. Hercules is the name come from the classical mythological hero, where the judge will also have plenty of time to decide the best of judgment. Hercules must construct a scheme of abstract concrete principle that provides a coherent justification for all common law precedent so far as these are to be justified on principle, constitutional and statutory provision as well. Hence, from this jurisprudence, the court was to decide as to frame the law in its best light to make the law the best it could be. The court will be acting on the premise that the law is seamless web. The court also is required to construct the decision that best fit and justify the law as a whole in order to decide any particular issue. Thus, the interference of the court will be the best and essential and determinant to come to the right answer. In conclusion, Social Media Defamation Act 2020 is comprehensive and it was derived from Western and Islamic jurisprudence. Therefore, with this act, we hope to prevent and provide justice toward the issue of defamation in social media. That's all from us. Thank you.